Rise. United States District Court for the Western District of New York is now in session. The Honorable William M. Scrutiny, Chief Judge, presiding.
Good morning, ladies and gentlemen. Please have a seat. I was going to wait a few minutes, but it was so quiet in here. I thought it's so on. I want to thank you for coming to celebrate with us Constitution Day. And for us, it's a very important day. And it is Article 3 of the United States Constitution that vests the judiciary with the power to interpret the Constitution and make decisions that are binding on the legislative branch, the executive branch of our government, and on all of us. So on this day, we are here, and we're really glad to have you party with us. All right, we celebrate the enduring guiding document that has given life and sustained our great nation for 226 years. You know, a lot of hard work has gone into making today possible, and that ranges from our school administrators to teachers and technical staff, and you know them, as well as some very dedicated court employees and technical individuals from the court. And very soon, we're going to step beyond them to presentations by Hillary Banker, an attorney, and Michael Perley, an attorney, both of ABOTA, which is that American Board of Trial Advocates, and Gregory Peterson, an attorney who is the co-founder of the Justice Jackson Center in Jamestown, New York. I'm confident that the hype about Constitution Day is about to become a reality, and that you are going to enjoy the presentations, and you're going to learn a lot from them. So to get the program started, I eagerly invite to the podium Attorney Hillary Banker. Hillary, if you would, please.
Thank you, Judge Scrutiny. My name is Hillary Banker, and I am the president of the American Board of Trial Advocates, or ABOTA. And I also welcome you all to the James Otis Lecture, our inaugural James Otis Lecture, which we hold in honor of Constitution Day. ABOTA is an organization comprised of 6,000 civil trial lawyers who represent both plaintiffs and defendants. To be considered for membership, you must have tried a minimum of 20 civil jury trials to verdict. At that point, you can be nominated by your chapter for membership if you meet the standards of ethics and civility that are required by the organization. There are 98 chapters across the country, and our chapter has 31 members. We all know about the right to a jury trial in a criminal case, but a lot of people don't know that the 7th Amendment of our Constitution guarantees the right to a jury trial in civil matters. The 7th Amendment states, "In suits at common law, where the value in controversy shall exceed $20, the right of a trial by jury shall be preserved, and no fact tried by a jury shall be otherwise re-examined in any court of the United States than according to the rules of the common law." This preservation of the 7th Amendment right to a civil jury trial is the primary purpose of ABOTA. Thomas Jefferson was of the opinion that the right to trial by jury of fellow citizens was a more important safeguard of personal liberty than the right to vote. With a jury, the rights and duties of each of us will be decided by our fellow citizens. An equally important mission of ABOTA is to ensure that Americans, and particularly our young people, understand the Constitution and the rights and responsibilities of citizenship. That is why ABOTA created the James Otis Lecture. You will hear more about James Otis later, but despite his significant contribution to the history of our nation, few people remember who he was or what he accomplished. So, to help revive the memory of this lawyer patriot, the Massachusetts chapter of the American Board of Trial Advocates created the James Otis Lecture. Today, as Judge Scrutiny mentioned, we celebrate the 226th anniversary of the signing of the Constitution. I am so glad that you are all able to join us for what promises to be a very exciting, interesting lecture.
Thank you, Hillary.
Just so that you know, you're not going to be alarmed over it. Just have some matters to clear up on this subject, so we tell whether it happened to you. So not to be concerned. My name is Greg Peterson. I am the co-founder of the Robert H. Jackson Center located in Jamestown, New York. Today, every one of you entered into a United States Federal District Courthouse, which is now known as the Robert H. Jackson United States Courthouse. Justice Jackson, native of Western New York, practiced law in Jamestown and Buffalo, and is the answer to the Jeopardy question. Name the only person in the history of the United States to be Solicitor General, Attorney General, and a Justice of the United States Supreme Court, and a person who was born in part of Western New York. I just wanted to tell everyone that what you just saw is an incident in this courtroom, which was a reenactment of something you're going to learn about in just a few minutes. We'll play it.
See, before the war, my parents were very proud people. They always talked about Japan, you know, and also about the samurais and stuff like that.
Bombing of Pearl Harbor and the entrance of the U.S. into the war, a lot of people saw that as a perfect opportunity to get rid of persons of Japanese ancestry.
Right after Pearl Harbor, everything just, you know, they were just real quiet. They kept it to themselves. They were afraid to talk about that. There had been so much friction between the United States and Japan, and the way Japan was so active going into China and doing all that, you know, invasion and so forth, that I had a feeling that, you know, they're just crazy enough to come down here. And that's what they did. At the nursery, my parents, they were all around the radio listening. They weren't saying very much. My mother was crying, my father was just disgusted. All that work that my parents did to that nursery and so forth, what's going to happen? A few days later, the police came down there and confiscated all the flashlights and cameras. They confiscated everything that they thought that we would use for signaling.
The Secret Service and the FBI had swept into the Japanese-American community and had arrested any community leader, any teacher, any civic organization head of any importance in that community.
I thought the exclusion order would be only for aliens, those that are born in Japan. I didn't think that the government would go as far as to include American citizens.
If you have the Western Defense Command who was in charge of our movement, if they come at you with a bayonet in your back and say you're going to move into a horse stall, you do.
The people that we thought were our friends, instead of helping us, they wanted to take things that they thought they could use themselves. That's because we couldn't take it with us. I went to San Francisco, first chance I had, and I talked to this doctor. I just told him that, you know, I've been harassed so much being an Asian that I would like to look more Caucasian. And he says, well, let me see what I can do. So I decided, well, I'll take a chance on it. He just slit my eyes, I guess, and took some of the skin off or something on both of my eyes. And that was it. It didn't work out right anyway. My mother recognized me. She knew me right away. Even my girlfriend didn't say too much. You know, I said, well, you look different anyway. You know, I felt uncomfortable was when I happened to glance at a newspaper or a newsstand where somebody looking at it, and it says Jap this and Jap that, you know, and all the bad things about the Japanese. I even refused to buy a paper because of that, you know. That was it until the time that I got caught. And then one day my girlfriend wanted to meet me. I was waiting for her at the corner, and she didn't show up. I ran out of cigarettes. So like a darn fool, I went across the street to the drugstore, and someone recognized me, I assumed, because when I came back and I was standing there for another 5 minutes, then the police came. And they looked around and looked at me and said, "Did you see any short Japanese person around here, Asian?" I said, "No." He looked at me and says, "Well, let me see your identification." By that time, the 2 MPs came in the military. And he says, "We have to take you to the city hall." After I was arrested, I never did see my girlfriend again. So there must have been something going on in there, but I didn't know.
We tried to find a legal challenge to the internment, but of course, in order to do that, you have to have a test case. So we were on the lookout to find a case of that kind. It wasn't easy until I heard of Fred Korematsu's case in the newspapers.
The judge said, "Since you violated the military order, the bail is $5,000. And to my surprise, Mr. Bessick took out his checkbook and wrote it out without hesitation and gave it to the clerk. And he says, "Come on, Fred." He grabbed all of me and we start walking out. You can hear our footsteps clunk, clunk, clunk toward the door, and we finally got to the door. We opened the door and I said, wow, the sun shining right in our face. And then I looked real good. There was 4 MPs standing there. And Mr. Bessick said, "We paid the bail. He's a civilian." And they would start pulling out the guns. And Mr. Bessick looked at me and he said, "Fred, you go ahead and go with them, and I'll keep in touch with you." When the MPs took me to a separate room, well, it was a horse stall, and it was way out on the other side of the racetrack. And they took me there in a pickup. But it was a big door for the let horses in. There's a gap about 12 inches down below. There's no floor, it's just dirt. So the wind was blowing through there, and there's cracks all around the wall. And there's a light bulb up there, one light bulb on the ceiling, and that was it. And I went there and I lied on the cot and I said, "Gee, jail was a lot better than this."
The vignette you just saw was dealing with Fred Korematsu, and a Japanese and American who was taken into custody in 1942. Not too dissimilar what just happened before you in this courtroom, where an individual was identified because of race and asked to leave, having had an alleged violation. My job here today is to talk a little bit about the Fred Korematsu case. Fred Korematsu lived at a time when relations between the United States and Japan were at a low ebb. They were strained. Japanese officials resented American involvement in Asia during the 1920s and 30s. At dawn on the morning of December 7th, 1941, it was clear that further peace talks between Japan and the United States would be pointless. On that date, Japan attacked the United States naval base at Pearl Harbor. and as President Roosevelt stated, a date that will live in infamy. The United States Congress responded to the attack by declaring war on Japan. Now, at that time, in that environment, not all the Americans showed anger towards the Japanese Americans. Some Americans wrote letters to editors of newspapers saying they were supportive of Japanese Americans as good citizens of the United States. However, that wasn't unanimous. A number of Americans worked very hard to make others doubt the loyalty of anyone who was Japanese and American. President Roosevelt in 1942 was convinced that the United States had to protect itself from invasion by the Japanese. He also wanted to protect America from spying by the enemy, especially sabotage. President Roosevelt signed a special order on February 19, 1942, called Executive Order 9066, which gave military commanders the power to select certain parts of the West Coast and call them military areas. The designated military areas were parts that the government thought Japanese might invade. That was the mindset of the United States during that time period. This Executive Order 9066 gave the military commander permission to keep out any and all people he decided were a threat. So they designated California, Washington, Oregon, and Arizona as military areas. On March 21, 1942, President Roosevelt signed a public law, 503, which made it a federal crime to disobey any government orders. They implemented a plan for the forced internment of Japanese Americans. The American military said the Japanese Americans were a threat to national security. The evacuees in the area where Fred Korematsu lived in the San Francisco area were told on May 3, 1942, that they would have to leave their homes in 5 days. Besides losing their personal articles, they had to leave behind the businesses. And as we learned, Fred Korematsu's family business had to be left behind. They sold it at an absolute loss. Fred Korematsu was charged with breaking Public Law 503, which made it a crime for Fred Korematsu to stay in the military area, San Francisco, after the Army announced that the Japanese Americans had to leave. He refused to leave and was ultimately arrested, as you saw, brought to court, and was found guilty of felony at the time, of felony. He was sentenced to a 5-year probationary term. As you saw, the bail was posted. An arrangement would be made that would last as long as Korematsu followed all the laws and obeyed any special rules. Well, what happened was the Army said, gee, you're still in California. We've got to move you. So they took him and they placed him in an internment camp, an assembly center. Even though the judge tried to release him, the Army took him away. He was sent to an internment camp in 1942, Tanforan, and he described the living quarters there as horse stalls, which were made for horses, not human beings. The only reason Fred Korematsu was held captive by the Army during this time period because he was a Japanese American. Korematsu said the orders and the Public Law 503 were against the Constitution, which is what we're here today to talk about. Korematsu's attorney appealed this sentence, and his case finally went to the United States Supreme Court. As we all know, the United States Supreme Court is the court of last resort in our legal system. According to the government in its case before the Supreme Court, the only issue was his refusal to evacuate. They said because you didn't leave California, you violated Public Law 503. That's why you were arrested, convicted, and became a felon. The Army, they felt that that law was legal because the Army had the right to remove Japanese Americans from the West Coast in order to relieve tension and the possibility of violence in the military area. Korematsu's basic appeal said he should not be treated any differently under the law because of his race. But as we mentioned, the Constitution is the highest law of the land. The War Power Clause gives the Congress the right to create any laws in order to win such a war. It also has a balancing act called the 14th Amendment, which guarantees equal protection under the law to all American citizens. Race, gender, or religion should not be factors in how people are treated under the law. There's also a section dealing with due process, which requires the same rules that are followed in every court case. The Army decided that Fred Korematsu was a potential threat because he was Japanese American. The Supreme Court heard oral arguments on the Korematsu case in October of 1944 and decided it on December 18, 1944. The court found it was constitutional for President Roosevelt to sign that executive order. Korematsu had admitted he knew the exclusion order but decided to disobey it as he felt it was against the Constitution. The Supreme Court reasoned that protecting America's West Coast was enough to withstand strict scrutiny. It was also decided that the law had a definite and close relationship to preventing espionage and sabotage. Justice Black, in a case, said the hardships are all part of war. All citizens feel the impact of the war in greater or lesser measure. There was a dissenting opinion, and this is what's important. Justice Robert Jackson, a Western New York native, your guy from Buffalo, Air Practice Law in Buffalo, wrote a dissenting opinion in the Korematsu case, which is quoted extensively in the Supreme Court. Because it was his opinion that said race-related portions, the race-related portions of the exclusion order seem very clear to him. Korematsu was born on our soil of parents born in Japan. The Constitution makes him a citizen of the United States by nativity and a citizen of California by residence. No claim is made that he is not loyal to his country. There is no suggestion that apart from the matter involved here, that he is not a law-abiding and well-disposed individual. Korematsu, however, has been convicted of an act not commonly a crime. It consists merely of being present in a state where he is a citizen, near a place where he was born, where all of his life he had lived. A citizen's presence in the locality was made a crime only because his parents were of Japanese birth. He went on to say, now, if any fundamental assumption underlies our system, it is that guilt is personal and not inheritable. Even if all of the one's antecedents have been convicted of treason, the Constitution forbids its penalties to be visited upon him, for it provides no attainder of treason shall work corruption of blood or forfeiture except during the life of the person attainted. Justice Jackson warned against the danger of the Supreme Court upholding a military order like this. He felt to do so was to give permission to a practice of racial discrimination whenever it became desirable for some reason to do so. He said the decision lies about like a loaded weapon ready for the hand of any authority that can make some argument of an urgent need to use racist rules. After the courts announced its decision, there was strong reaction on all sides. Others felt the Army's actions were wrong, and the Korematsu decision created bitterness and resentment in the Japanese American community. Justice Jackson always viewed Korematsu as civil liberties decision. He also saw that regular civilians having the power, has the power, regular citizens right here, has the power to prevent abuses. Thereafter, the case, new efforts would be made to clear Fred Korematsu's record. However, the principles that were part of the Korematsu versus the United States continue to be played out today in cases regarding racial profiling, illegal immigration, and so on. And we will hear more about that. Thank you very much.
Thank you, Greg. Soon we're going to move on to another speaker, but first we're going to talk about some aspects of the Korematsu case, but in the context of the federal court system And I'm going to take you for a brief tour of that system through Fred Korematsu, and keeping in mind that defendants today go through this federal system in a fashion very similar to what Fred Korematsu experienced back in his day, so to speak. You heard Greg Peterson eloquently explain the political and historical and contextual background of Fred Korematsu's case, and you heard him discuss some of the poignant details of the Supreme Court's decision in that landmark case. But what I want to do is talk today a little bit about what I think is interesting and relevant to your being here today, and that is that when Fred Korematsu was first convicted, it was in a what we call district court, just like this one that you are sitting in this morning. The difference being that that particular district court was located in California. And as Greg mentioned, the Supreme Court, where the case ultimately was finalized, is and was then the most important court in our land. But district courts like this one are where much of the action happens. Why? Because we're the trial courts. That's where the trials take place. And federal court judges are nominated and appointed for life by the President of the United States, subject to confirmation by the United States Senate. And because federal judges have life tenure, they cannot be removed merely because they decide a case in a way that some people or some special interest groups or politicians may disagree with. Every day, as you know, people are arrested, then brought into federal court for arraignment, hearings, and trials, just as Fred Korematsu was over 60 years ago. Fred was arrested on May 30th, 1942, brought into court before a federal judge, like me, who explained to him the basis for his arrest, asked him to enter a plea of guilty or not guilty, and then decided whether he should be released on bail. As you know, that's called an arraignment. Judge McCarthy and Judge Scott, they conduct arraignments here for us in the Western District of New York almost every day. But in the Korematsu case, eventually Fred was tried and convicted and then sentenced, and the sentencing took place in California, not here in New York. Interestingly, the founding fathers of our great country believed that the state courts should control and enforce the laws that control much of everyday life. The New York State court system is where Justice Perodato and Judge Egan serve. The Korematsu case was properly in federal court, though, because it dealt with, as you heard, the violation of a federal law. But had Korematsu violated the law of the state of California, he could not have been prosecuted in federal court. In the federal system, there are 12 circuit courts for litigants who believe a trial judge committed prejudicial error of some kind. Fred Korematsu appealed his case to the Ninth Circuit, which hears appeals from a wide range of Western states, including California. We in New York State are part of what is known as the Second Circuit Court of Appeals. In Korematsu's case, the question was whether the law that Fred violated was constitutional. The appeals court found that the law was and affirmed the conviction, and this left Fred Korematsu only one other place to turn, and you know what that is, and that's the Supreme Court of the United States. Our Supreme Court is located in Washington, D.C., and it consists of 9 justices who hear cases from all over the country. Majority rules in that court, so that 5 votes is all that is is required to decide a case. And generally, the United States Supreme Court hears only about 100 cases each year. And most often, those are the most important cases of that period of time. You now know the outcome of Fred Korematsu's case in the United States Supreme Court. He lost by a vote of 6-3. But Justice Jackson, for whom this courthouse is named, authored that famous dissent in the case that Greg Peterson just mentioned. It was an eloquent, well-crafted denouncement of something that we should all be sensitive to, and that is racial discrimination. So in short, that's the three-stage part of the federal judicial system. The district court, which is the trial court, the circuit court of appeals, which is the appellate court, and the ultimate court, the United States Supreme Court. So without going to any more detail, I want to thank you for listening to me. And we're now going to ask Michael Purley of ABOTA to tell us about James Otis, after whom this particular program and lecture is named. And he will highlight for us some of the related contemporary issues that pertain to the Korematsu case, like profiling of non-citizens and stop and frisk laws, which will be discussed in our breakout sessions that follow this morning's presentation here in this courtroom. So, Michael, if you would please, I think everybody's anxious and looking forward to your remarks.
Thank you, Judge Scretany, Justice Perodato, Judge McCarthy, and Judge Scott. Good morning. Obviously, I'm Mike Purley. The Korematsu case, like many cases decided by the Supreme Court, while it had factual issues that were compelling, involved the court in a broader consideration of issues, and those issues centered around the limitation of power in the United States government, the extent of that power, and the rights of individuals. Now, Korematsu lost that case, but the principles remained. And the core principle that I see the court deciding day in and day out when it hears these appeals is the question, it can be phrased this way, that in a civilized society, the power of the government is not unlimited, but likewise, individual liberties are not absolute. This principle was strongly advocated by John Locke in the 18th century. And the 18th century is when our country was formed. Locke had said, even before our Constitution was written, that the end of law is not to abolish or restrain, but to preserve and enlarge freedom. And in the end, where there is no law, there is no freedom. These issues were at the core of James Otis' resistance and defense when the Customs Office in Massachusetts in 1760 sought to obtain a search warrant, known then as a writ of assistance, in the broadest possible terms. That warrant, as some of you may know, would have allowed the English and the Customs Office to search anyone, anywhere, anytime, and for no reason at all. Now, warrants had existed in colonial America, but those warrants were similar to the warrants that we know of today, where the Customs Office would go to the court and show a reason to have a warrant and designate the place and the person to be searched. This warrant was entirely different. Otis argued this case in February of 1761 before the Massachusetts Superior Court. The application for the warrant was presented by the government. And the government's basis and its reason for seeking that warrant was simply this. There was a need, there was necessity in the government to have a warrant so broad. Why? The purpose of the warrant was to enforce the Navigation Acts. And those Navigation Acts imposed tariffs on the colonists. What the colonists were doing was they were essentially taking a large percentage of the goods that were traveling in and out of the colonies, storing them away from the ports and loading those ships in part in secret to avoid paying the tariffs. The reason that the government needed, or it said it needed such a warrant, was because by the time it obtained the warrant, the colonists would have had an opportunity to move the goods. Otis argued eloquently against this warrant. And he argued based upon the principles of the British Constitution that finds its origin in the Magna Carta in 1215. He said, "The reach of this government is not unlimited. It should not be able to search anyone without cause." He also said this, "We understand that the English subjects in England are not subject to these warrants, and we should be treated no differently than they are treated." Otis never said the government didn't have the authority to get a warrant of some kind, but he argued that a warrant so broad and so invasive would essentially destroy the rights of individuals in the colonies and leave open for any individual to break the boundary of another individual's rights. If you stop and think about it, ladies and gentlemen, you can see the beginnings of not only our Constitution, but our Bill of Rights. This question survived the 18th century and has been a part of this country ever since our founding. Questions are presented in different forms. For instance, how far and under what circumstances can a government intrude in the lives of its citizens? Under what circumstances can it treat one group of citizens differently from another? And how far do our individual liberties extend? It is a balancing act where the needs of the governments and the rights of individuals are weighed, and they're weighed by the courts. They're weighed by this court, they're weighed by the state courts, and they're weighed by the Supreme Court. Now, since Otis made the argument in 1760, we have had the benefit of a Constitution. And that Constitution and the Bill of Rights that followed it and the amendments that followed the Bill of Rights have helped define these interests. The Fourth Amendment protects individuals from unreasonable search and seizure, the very argument that Otis maintained in the Superior Court in Massachusetts in 1761. We have the Fifth Amendment, which guarantees individuals the right to due process, and the 14th Amendment that extends those rights to citizens in actions by the state, and also provides us with the privileges and immunities of the citizens of the United States and the right of equal protection for all of us. How did this play out in Korematsu? Obviously, it's a poignant case when you listen to Fred Korematsu talk. But it cannot be forgotten that America was at war when this happened. There was a fear of invasion. Invasion of the United States last occurred, or there were foreign troops on the soil of the United States, last happened in 1814. Looking back, it is easy to consider that the court overreacted, that the citizens overreacted, that maybe Congress overreacted. But we know now, in hindsight, how the war ended. At that time, no one was as certain. You have to remember this, too, about the Korematsu case, that it was a military order. That is different than what we see in our lives on a daily basis. We don't deal with military orders quite so often. When the Supreme Court decided the Korematsu case, it had to balance those factors that I mentioned earlier. The extent of the government at war, the extent of the government's powers at war, and the rights of individuals. The majority, when it balanced those interests, balanced them in favor of the government. Jackson's dissent is an eloquent statement in defense of the rights of individuals, particularly the rights of individuals who are in ethnic minorities, and the rights of those individuals, for that matter of all individuals, without regard to their race. Boiled down, Jackson's dissent merely said that the only crime Fred Korematsu committed was to live in California. However, it is important to remember that Justice Jackson's dissent and his reason for disagreeing with the majority wasn't based upon the military order. He said in that dissent, "A military order, however unconstitutional, is not apt to last longer than the military emergency." What concerned him was this: once a judicial opinion rationalizes such an order to show that it conforms to the Constitution, or rather, he said, rationalizes the Constitution to show that the Constitution would sanction such an order, the court has for all time validated the principle of racial discrimination. Strong words, a strong concept. What concerned Jackson in my mind, and Mr. Peterson, Greg knows much more about Judge Jackson than I do, and may have forgotten more about Judge Jackson than I'll ever know. But what seems to me concerned Jackson was that the fact that the court would agree to this and uphold a felony conviction. Let's move this forward to where we are now. Since Korematsu, we have had Brown versus Board of Education, a landmark decision in confirming the rights of all individuals to have equal access and equal opportunity. But more pressing today are the issues that face our country in terms of illegal immigration, a hot-button issue in every presidential campaign, along with the problems, especially in the larger cities, of crime and the ability of the police not merely to investigate crime, but to prevent crime. So let's talk about those two issues, if we can, for just a few minutes. In 2010, the state of Arizona was confronted with a problem. It had, within its boundaries, by its own count, 460,000 illegal immigrants. That is twice the population of this city. That number had risen by 5 times since 1990. The border between Arizona and Mexico is an open border. And there is a border station known as the Tucson Station in Tucson, Arizona. And the highest number of arrests for illegal immigration occurred in Tucson. In addition, in 2010, the economy was in recession. The finances of the state were challenged. Arizona believed that the federal government could not help them, that they had to help themselves. This was their necessity. Like in the Otis case, their argument was, we need to do this. We need to do this in order to protect our citizens, in order to run our state properly. And they enacted a law. The law did a number of different things. It made it a crime for aliens not to register with the federal government. It made it a crime for aliens to seek employment in the state. It required state and local police officers to determine, where practicable, the immigration status of any person they stopped, any person they detained, wherever they had a reasonable suspicion that those individuals were in the United States illegally. It also required state and local police officers, or empowered them, to arrest without a warrant any person, including a person lawfully in the United States, if they had probable cause to believe that such person had committed an offense that could result in their removal from the United States. Strong stuff. And the response to that law, especially outside of Arizona and even within the state, was that it clearly targeted two ethnic groups, the Hispanic and Latino population of that state. The law didn't say it. According to these people, the law didn't have to say it. It was abundantly clear. This case went to the Supreme Court of the United States. The proponents of the law, like I said before, argued the necessity of this law, that we needed to do this. And when asked how they would justify the detaining or arresting of people, the proponents argued, those in favor of the law argued, that the reasonable suspicion standard would justify it. And they further said that, understand this, the detaining of an individual upon reasonable suspicion that they're not lawfully in this country could only be made after there was an otherwise appropriate stop. In other words, an otherwise appropriate reason for them to stop that individual, be it a traffic stop, be it probable cause that a crime had been committed. But that stop in and of itself had to be appropriate first. The United States Supreme Court decided this. It first decided that the federal government had preempted the state of Arizona and that it could not make it a crime not to register. It could not make it a crime to seek employment because the federal law already did that. It also struck down and held unconstitutional the provision of the law that allowed individuals to be arrested if there were probable cause that they had committed a crime that would subject them to deportation. Once again, they said the federal government had preempted that, and it was their responsibility and not the state's. But what was significant to us today about that decision is the fact that they upheld the provision that allowed detaining of individuals upon reasonable suspicion. Why did they do that, and how does that fit with what we've talked about? Well, first of all, the court engaged in what we've talked about already, a balancing test. They balanced the legitimate aims and power of the government against an individual's right to remain free and uninterrupted in their daily lives. And the court said this, because there was already an appropriate and constitutionally justified stop of that individual, the detaining of the individual based upon reasonable suspicion was acceptable. That was a legitimate exercise of the power of the state and the police in order to determine the immigration status of the individuals. Within that balancing act, that one provision in the state of Arizona survives and is available to the police and the law enforcement. The court further said, had you based that solely on the racial origin of the individual, had that been your only test, the law would clearly have been unconstitutional. A justification, I submit to you today, of Justice Jackson's dissent in Korematsu. Lastly, I want to talk about the stop and frisk policy in the city of New York. This has been in the news. It is, once again, a hot-button issue if you're in the city of New York. And this case is only at the district court level right now. It was decided by Judge Scheinlein, I think you pronounce her name, if I pronounced her name correctly. And it was held to be unconstitutional by her, and we're going to talk about that. But as Judge Scratney indicated to you, that there is an appeal court, and that is the Second Circuit. And this case is on its way to the Second Circuit as we speak. So today when we talk about this, we have no answers, but we do have questions, and we do have thoughts. And we do have an opportunity for you to think about this and discuss it in a few minutes. New York City, because it saw itself having a significant crime problem, decided that one of the ways it could alleviate that problem was to, quote, stop, end quote, any individuals if they had a reasonable suspicion, remember those words were from the Arizona law as well, that a crime had been or was about to be committed. The police department could frisk individuals if they had a reasonable suspicion that the person was armed. Since the implementation of that policy, 88% of the people stopped have not been arrested. And in only 0.15% did they find a weapon. The criticism of the policy was that it unfairly targeted the black population in the city. The city's response was, they are targeted because those are the high crime areas. We targeted the areas, not the individuals. The district court has stopped that policy. They issued a judicial injunction preventing the city from enforcing the policy at this time, and the matter is on its way to the Second Circuit. But it all should give us pause as to where we want, or where we think, the balance ought to be between the power of a government to protect its citizens, to prevent crime, as well as to solve crime. And do they overstep their bounds when, as a practical matter, it affects one racial minority more significantly than any other? And how do we address this problem appropriately? I tried to leave you with questions rather than answers, because in a few minutes we're going to adjourn to the jury assembly room on the second floor of this building, and you will have a moderator at your lunch table. 4 of the moderators are sitting in the jury box, Mr. Radlin, the judges. I will be at a table as well as some others, and Judge Egan has just joined us in the back of the courtroom. I want to thank you for coming, Judge, and she will also moderate the discussion. All the moderators have had access to materials before today, and they will discuss with you the questions that I hope I've prompted you to think about. One last item before we leave. You have not heard all of Fred Korematsu's story. So I ask you to sit here for about 2 or 3 more minutes and watch with me how Fred Korematsu's story ends. Thank you.
In 1942, an ordinary American took an extraordinary stand. Fred Korematsu boldly opposed the forced internment of Japanese Americans during World War II. After being convicted for failing to report for relocation, Mr. Korematsu took his case all the way to the Supreme Court. The High Court ruled against him. But 39 years later, he had his conviction overturned in federal court, empowering tens of thousands of Japanese Americans and giving him what he said he wanted most of all, the chance to feel like an American once again.
I am a teacher, and I brought my class with me, and as an impressionable group of young people, and you were being described by so many as an activist, is there something you'd like to leave with them, or some message that you'd like to have them take away with them?
Yes, I would. And to believe on the Constitution, and also anything that's within rights. If you think you're right, and go along with it, and to fight it, you know, to not to give in. Like I did. I knew, you know, hey, it's against the Constitution what they're doing. And, you know, even though, you know, like in here, you know, like I say, hey, what we're doing here is wrong. And I don't hear anything about the rest of them. So maybe they're right, you know, and I'm wrong. But I'm going to find out. So stick to your guns.
In the long history of our country's constant search for justice, some names of ordinary citizens stand for millions of souls. Plessy, Brown, Parks. To that distinguished list, today we add the name of Fred Korematsu.